Hi everyone, welcome to HRMS Adda by Flexially, where we discuss elaborately about human resource management system. In episode 1, we discussed characteristics of HRMS platform required, and the episode 2, we talk about what are the points to keep in mind while selecting the HRMS service provider. Today we are going to discuss what are the important points to keep in mind while signing with the HRMS service provider. If you have not watched our previous episodes yet, I will link to in the description box or in the I button. Check it out for better understanding. So let's get started with today's episode. After selecting which HRMS software you want to implement in your organization, the next step is to prepare an agreement. While preparing the document, many organizations made small mistakes. To avoid any disagreement, today is about explore the safeguards for the organization. To help us out about the agreement, we have Ms. Kamla Naganan from Arna Law. She has been enrolled herself as an advocate since 2005. She is a member of the International Technology Law Association. Thank you for joining us, ma'am. We are grateful to have you here.
Thank you for having me.
Thank you. If we start with the basics, the agreement should explicitly outline the names of the parties, the start date, and a comprehensive description of the services to be delivered. What is the other fundamental information that should be included in an HRMS agreement?
I think some of the things that we need to keep in mind while choosing an HRMS platform is how many people are going to be using it, how many offices are going to be using it, and the kind of geographies that you're going to be using it in. Because if you ask a company that has offices out of India, you'll have to make sure that that relevant law is applicable and the regulations within that particular jurisdiction are complied with by the HRMS platform. So I think what's very important is for you to be aware of what are the regulations in the jurisdiction where you are going to be using the platform and make sure that the uh, HRMS software complies with those regulations.
That's a great point. Moving on in terms of tenure, I think it's advisable to start with a short term agreement, especially if you are new to HRMS. How should the agreement address the duration of the contract?
I think usually it's very clear. HRMS platforms provide you a 6 month and then an extension of another 6 months, and then after that, a yearly program. So I think if you're able to, in the first 6 months, assess it, some HRMS programs also offer a 3 month free period in which you try out the platform to see if you like it. That way, you're spending a lot of time saving. Uh, there's a lot of time saving because you're able to ensure that the product is to your liking and the whole transition from your present HRMS platform to the new one is not a problem.
Absolutely. Since HRMS software is cloud based, what key considerations for hosting and security should be included in the agreement?
I think basic things like encryption today in terms of data security is primary. So ensuring that firstly the HRMS software complies with data security protocols. And by this I mean that they should have proper regulations put in place to ensure that the data is encrypted and there should be end-to-end encryption. To where the data is going to be hosted should be very, very clear. It should ideally be in the same jurisdiction where the organization is based. Regulations in India make it very stringent to ensure that you have data of an employee in the same jurisdiction where you are located. So you cannot have Indian data located in the US or the UK on data servers there. I think the second thing is what is the kind of data security? Is there anonymization of data as part of the HRMS platform? Because ultimately you're going to have personal sensitive information like bank accounts, email addresses, access to phone numbers, health records. So all this is personal sensitive information, and you should have, as an HRMS platform, a data security officer and ensure that the data security officer works with companies to make sure that your data is saved in a very, very comprehensive manner without there being any compromise on security.
Very important to cover that. Next, how the agreement define roles and responsibilities between the organization and the HRMS service provider, and what should it specify regarding the uses of the HRMS software?
I think the biggest problem we see in terms of a dispute is in this section, where it's not clear what the role of the HRMS software people are, what the role in of the customer is. And very often you have a customer success organization in the middle who manages all the transition from the old organization to the new organization. And that's where I think most customers have issues with HRMS software because the roles are not defined. I think it's very, very important in the contract to define roles, especially with regard to migration of data and
Mhm.
data security in that process. Also, it's important to be clear as to what is the role of the customer and what is the role of the HRMS organization, and what is the role if you have in your organization a customer service uh, organization which is going to help in this transition period. What is their role?
That really clarifies the ownership aspect. The agreement should outline authorized users, access restrictions, and third party access. What should be the aspects the agreement specify regarding usage of the HRMS software?
I think, firstly, according to law and according to the Indian Data Protection Act, only people
Mhm.
who need access to the data should have it.
Mhm.
Second, the data, when saved, should be done in an encrypted manner such that if there is a data breach in the organization, the individual's records are not made public. Three, the data protection officer, because ultimately this is an organization which is a data fiduciary. What is a data fiduciary? One organization that has a large amount of data that it is collecting or it is privy to. So the data protection officer should be available in case there is a breach. There should be clear protocols on what happens if there is a breach. And finally, the training should be given to every member of the organization within the HRMS software to say if there is a breach, how they are able to respond.
That makes a lot of sense. Now, if I talk about pricing, what pricing factors should be included in the agreement?
I think I don't want to comment on pricing because this is something that is so personal. Each HRMS software has its own methodology of pricing, and it's a commercial decision between the organization and the parties. So you can have any pricing as long as it's clearly enumerated in your contract.
Right. Speaking of legal aspects, what should the agreement address in terms of compensation, penalties, and data privacy requirements?
I think data privacy have been very clear. In terms of compensation, the Data Protection Act itself has very, very clear guidelines on what the compensation should be and the kind of penalties that are to be incurred by parties failing to ensure that data is protected. But what, as an organization, you should make sure is have stringent policies put in place for your employees to say if there is a data breach, then there is absolutely no cover up by the organization. There is ownership and there is very, very clear methodology of sanction.
Agreed. Data privacy is key. Lastly, the agreement should outline the terms for ending the contract, transferring data, and getting help during the switch. What should the agreement include regarding termination?
I think there should be clear termination clauses identifying what the timeline is and what happens to the data during termination. Because as an HRMS software, you have a responsibility to ensure that all the data is transitioned in a smooth manner. At the same time, you are not held liable for any breach during that transition process when they move from one organization to another. So I think, simple things like ensuring that there are clear guidelines put in place to say what is it that you will do as an organization to help transfer the data should be enumerated. Also, if there is a good, clear timeline in terms of 2 months, 3 months, 4 months, you're able to transition the data not overnight, but in a seamless manner without risk to security.
That concludes our discussion on the key points to consider when drafting an HRMS agreement. Remember, a well crafted agreement is essential for protecting your organization's interests and ensuring a smooth HRMS implementation. Thank you, ma'am, for sharing your knowledge with us. I hope our audience will benefit from today's podcast.
Thank you. Thank you very much. Really appreciate it. Bye.
Thank you for watching the video. Don't forget to like, share, and subscribe to our YouTube channel. Make sure to follow us on Instagram, LinkedIn for such informative content. We will be back again with another episode. Thank you.